Mr. Burnham, I'm going to ask you to look at the options paper that was provided pursuant to the requests that have been made. It's DHSC 00413070_015. It's dated the 3rd of March 2010, and the purpose is self-explanatory. Paragraph 1, to provide advice as you requested on 2 options to further support patients infected 20 or more years ago with hepatitis C and or HIV as a result of treatment with contaminated blood products and their families. And then there were 2 options. Option 1 was about whether a scheme for funding for those with thalidomide could be applied to those infected by contaminated blood. And option 2 was the bringing forward of the review of the Skipton Fund. We can see the heading recommendation, paragraphs 4 and 5. The recommendation in relation to the thalidomide scheme was that it wasn't an appropriate scheme to apply. And then in relation to the option that you and Gillian Merrin had been particularly interested in, the bringing forward of the review of the Skipton Fund, the advice at paragraph 5 is we have agreed with DH Finance that we are unable to recommend that the review be brought forward because the department is overcommitted on funding for 2010-11 and the financial position in subsequent years will be extremely tight. If you wish to fund a review, then decisions will be needed on cuts to other priority programmes. Just pausing there before we look at the remainder of the paper, that was a pretty clear steer from officials, was it, not to go ahead with what you proposed?
Yeah, it was.
If we go over the page, halfway down the page, there's a further discussion under the heading option 2, reviewing the Skipton Fund. Paragraph 8 refers to the likely costs if the review resulted in additional money, many tens of millions over the next few years, and there are significant risks attached to this. Paragraph 9, if you still wish to consider a review, we would recommend the following principles be applied. And then there was specific funding envelope, clear and specific focus to steer its work, and structured to enable the funds to be allocated to the Skipton Fund in 2010-11. There's then paragraph 10 under the heading resource implications, the warning that this would add many tens of millions of pounds to the cost of the Skipton Fund over the coming decade. If we go over the page, under the heading risks, paragraph 12, you're told there are some significant risks associated with bringing forward the review. A concerns the campaign for money and the fact that the department is currently defending the judicial review of the government's response to the Archer recommendation. 2 is then talks about the challenge of in terms of funding allocation. C, there may be criticism about the opportunity cost to the NHS of expending limited resource in this way. Do you know what that meant?
That there would be a cut to a priority programme, as it said earlier, and if you did something to expand the resources available to the Skipton Fund, that would require suspending a public health programme or...
And then D is that it would need to be agreed with the devolved administrations. E is the suggestion that other groups, such as those affected by VCJD, may be stimulated to increase pressure for more funding. And then F, finally, whenever the review is undertaken, addressing the issue of payments, especially to dependents of those who died before 2003 and who are currently ineligible, will be difficult. Given the destruction of the medical records after death, it will be difficult to establish criteria that distinguish between genuine claims and erroneous or fraudulent claims. And then if we go over the page, paragraph 17 concludes, because of the funding situation, we're unable to recommend that the review be brought forward. There are various annexes I'm not going to go through, but annexes that talk in detail about why the thalidomide approach was not appropriate, and then in relation to the Skipton Fund give further figures, facts and figures. Just one other document before I ask you about this. There's a further submission, 17th of March 2010 at DHSC 00413070_014. This is addressed again to Gillian Merron, and paragraph 1 says that further to Rowena G-Cock's submission of the 3rd of March, which we just looked at, you've asked for further advice on options for bringing forward a review of the Skipton Fund. There's also the reference to the possibility of personalised budgets. There is then further advice set out. I'm not going to read that aloud, but if we go to the recommendations on the next page, please, Lawrence. Under the heading Recommendations, paragraph 6, due to the complexity of this review, the potential legal repercussions and the far-reaching implications for other government departments, we strongly advise not to rush any review, especially having decided so far to maintain the existing position. There will be many legal and policy requirements we will have to address, and we think it's highly risky to promise something in a hurried way now that may prove to be difficult or not possible to achieve. We also run the risk of exposing the department to further legal challenge by way of judicial reviews. We therefore recommend that you hold the existing line and do not change the current commitment to review the Skipton Fund in 2014. If, however, you do wish to bring forward the review date, a great deal of care will be required from the beginning to manage campaigners' expectations. And there's more set out there. We just go over the page. Paragraph 9 warns that commitments may need to be cleared in advance with the Treasury, and so on. So would it be right to understand this further follow-up advice is equally strongly, if not more strongly, advising you and Gillian Merron not to bring forward the review date?
Yeah, I find it quite outrageous, to be honest, the way in which they were pressuring us and presenting us with a one-sided case, all about the finance. As I say, not any kind of sense saying, yes, we understand why you want to do this because of this and the suffering that people are going through, the inadequacy. They should have started with, we know, Secretary of State, why you want to look at this, because you heard from Fred and Eleanor Bates that, you know, they had to beg for a mattress. Yes, that, you know, and we, where is that? That's just totally absent from this. And I just think it was a reflection that the department had this in. As I say, and I'm not saying this out of malice for the department. I had a huge amount of regard for the department and the people who worked in it. But on this issue, they fundamentally had it wrong. And they could not, you know, there was just no humanity at all in this. I mean, this is pressurising ministers against helping people in a desperate situation. I mean, how would they justify that now? What this should have said was, we know it's your intention, because I said that, it was our intention to bring forward the review. Here's how you could do that, but here is the places that you will have to. But they didn't. It's really, that is what you would expect normally if you were minded to do something, which we were. And this, you can see this as the department, I wouldn't even say lobbying ministers, pressurising ministers to, you know, drop it, basically. And it does make me fairly angry, actually, to reread this. I think they thought, oh, well, they're nearly out of government, and what mandate have they got? Blah, blah. Hence, a memo, a note of this kind. But I think it does say something about why are people in this room, why are families across Britain still fighting for justice on this? Because there is too much control of these issues, and it could be, you could name a whole heap of other issues other than, I mentioned Hillsborough today, but nuclear test veterans would be a very good kind of comparator with contaminated blood, where you have thousands of people exposed to nuclear tests without, not just about their consent or their knowledge. These were servicemen, largely, some women I think, but mainly the vast majority servicemen. No PPE, but they are still in the same position today. And this says something that's wrong here, that it's a chance, really, that I got the protest, Alf, Paul, the meeting in my office, and then coming back and wanting to do something. But you can see then how hard it is to do something that I would say is in the interest of natural justice. And I hope the department is uncomfortable rereading that note that they put to me as Secretary of State when I was trying to do something which I believe I should have been doing in the public interest.
If we look then at the further discussion you and Gillian Merrin had, which is DHSC 56165528, and we go to page 4. And just before I look at that, for the record and for the benefit of others, pages 2 and 3, which I'm not going to go to, record conversations with Nicola Sturgeon and with Edwina Hart, who were content for the review to be brought forward, or had no problem with it being brought forward. Page 4 here, bottom of the page, it's dated the 25th of March, and it refers to a constructive meeting, a very constructive meeting yesterday, so presumably the 24th of March. As a brief summary for those not at the meeting, SOS, so that's you, and MSPH, Gillian Merrin, were clear that although they recognised this was a very difficult area, they were keen to take action on the issue of contaminated blood because they felt on a number of policy issues the department's line could not be maintained. There was a broad discussion of a range of different policy options along with the associated risks. Ministers had a clear preference for option B in the submission, bringing forwards in full the review of the Skipton Fund. They were attracted to the idea of placing a finite funding envelope on a review and of addressing anomalies with regard to widows, but were persuaded by the various legal risks that these options would be extremely hard to implement. Ministers have therefore urgently requested some further briefing on how the review could be brought forwards and what the broad scope of such a review would be. This should not be in the form of detailed terms of reference, but explore options for any constraints that could be placed on the review. So that the outcome of the meeting that you've had, it would appear to be pressing ahead, bringing forward the review from 2014 to an earlier date. Do you have any recollection yourself of that meeting?
I do, and you know, I think the inquiry will hear from Gillian Merrin, and I hope you do, because she was a great support to me in this period of time, and I do think at times it has to be understood how hard it is to be a minister, not just facing this kind of pressure, but look at the date, Monday the 29th of March 2010, we were running out of road, is the polite way of putting it. You know, the PERDA period in advance of the 2010 general election was basically upon us, and we were trying to get something away, you know, and the department, I think, was trying to, well, it was trying to stop us.
If we look at ARCH 0001105, we will see that, and I think one of the last acts or decisions before PERDA made it anything further problematic was this. So this is the written ministerial statement from Gillian Merrin, 6th of April 2010, further to the government's response to Lord Archer of Sandwell's report, etc., etc. I wish to inform the House that we have decided to bring forward a review of the Skipton Fund, which makes ex gratia payments to those infected with hepatitis C as a result of their treatment. The unintended and tragic consequences of these treatments have seriously impaired the lives of many people, together with those of their families. We've listened carefully to the views of those infected, their families, carers, and many in this House who have told us that our intended review date of 2014 will be too late for many of those affected. Consequently, we have decided that the review will begin as soon as possible this year. It will be an independently chaired review. The terms of reference, membership and conduct of the review will be agreed in conjunction with the devolved administrations. And as I understand it, Mr. Burnham, that's really the last involvement you and Gillian Merrin had with this issue, because, of course, the general election happened not long after this. And the question then of any review and how it would be implemented would be a matter for the new Conservative government.
Not quite. So this day, I think this probably was the last sitting day, possibly the second to last, and I think Parliament was dissolved not long after.
12th of April.
So we were in the last knockings of that Parliament. I think I left the Department of Health on the 12th of April and actually did not physically return to the department. The reason I say not quite is because the March judicial review, which I had not, as you said before, had much involvement in, it was presented as a sort of narrow review, I think, on an element of the Archer report. it obviously reported back before the general election when notionally I was still in office, and it was Secretary of State and had to be consulted because there was a sort of a thing about appealing. So the department at that point was much more in control of matters, and I was out on the campaign trail, and they, I think the papers might show it. I mean, I told them to be sympathetic and point to this review, because even I at that point, if I'm being honest, couldn't open up the island comparison because I just didn't know how I could, if I was in the unlikely event return to the Department of Health, I would have not known how I would have been able to pursue that given what I was facing. But that was the final involvement.
And just to get the dates, I think the general election was called on the 6th of April, which was the day of the written ministerial statement. Parliament dissolved 12th of April, general election 6th of May. The judgment in the March case was delivered on the 16th of April 2010. And you're right, there were some communications, I'm not going to take time going to them, but about how any response to them should be phrased. I think we need to go to the judgment itself. I'll read out the reference again so that others can find it if they need to. It's DHSC 0003819_011. The effect of that, the finding of Mr. Justice Holman in that case was to say that the department had made an error in the way in which it had characterised the difference between Ireland and the United Kingdom. I'm summarising rather than going through the details of the legal argument. And you refer to advice in relation to appeal. I think the advice you received was that the prospects of an appeal were weak. And again, the reference for the transcript of that is DHSC 50812242. Is it a concern for you that in the basis upon which the government in part had rejected one of Lord Archer's recommendations and a line which the government had taken in relation to Ireland was found by the court to contain an error?
Absolutely. Great concern, given that these lines were not just entered into a legal process, they were given to the Minister of State, Gillian Merrin, to say a number of times in the House of Commons,
Yes.
to Baroness Thornton, to Lord Warner, to a whole number of people who, and I think faithfully read those lines out, because the ministers wouldn't have had the chance really to go back and check. And it's a serious matter, a very serious matter, for the government to be giving ministers something so clear-cut. It's not the same, not comparable. And then ministers putting that on the parliamentary record. And then a judge finds that it is comparable. And I think that is serious. And the Department of Health, I think, if the inquiry chooses to make comment on this, they need to be challenged, in my view, how they could be. And it wasn't just that, of course. I was talked about the sentence in the Tonkin letter. We went through before the break some of the statements that were made in briefings. I've used the phrase, and maybe we'll come on to it, about how, in my view, what happened here was, and I don't use this word necessarily in relation to the Department of Health, but I've used it more broadly about a criminal cover-up. I think you cannot conclude otherwise, I don't think, that there's not a cover-up going on here, in that ministers are being given inaccurate information to put before Parliament. That is a very serious situation.
In terms of the March judicial review, the decision as to how to respond to the finding in terms of taking a further decision then fell to your successor rather than to you, because it was a new government. So you had no further involvement in deciding whether the government should now accept the Archer recommendation.
I think that did fall to the new Secretary of State. I think I was asked to sign off a statement, I think, in response to the ruling, the handing down of the ruling. and I required it to be changed to make it more positive about the review that we'd just announced. But I think that was my last involvement.
But more generally, how does a minister change direction, change policy in a department where officials don't agree with it?
You stick to your guns. So I had to do it over the appointment of Sir Robert Francis to conduct the first independent inquiry into Mid-Staffordshire, because the official advice was that there should be no process of further inquiry. So I had to say thank you, but I'm overturning that, and I'm not accepting that. And it's for all the reasons that you can see in terms of the pressure. And bear in mind, the minister wants the department's support in other ways. So it's, you've always got to bear in mind that this was only one issue, and within 50 that you were dealing with, it's not easy. But I suppose I've been a minister long enough at this point to know that if I was doing something, I was going to do it. But you just have to be ready for, the sort of sense of the place is kind of not with you anymore.
I want to turn next to the question of public inquiries. Obviously, no public inquiry was directed either when you were Secretary of State or at any earlier stage until much more recently. I think it probably follows from everything you've said over the years since you were Secretary of State that, but please correct me if I'm wrong, that it's your view that a public inquiry or some form of inquiry, independent of government, should have been held much earlier.
For certain. I mean, I said as much as Shadow Health Secretary. At the time I was Secretary of State, I'd not come across the equivalent evidence that I got on Hillsborough, which was multiple amended police statements. I didn't have the grounds upon which to say, I've got the evidence, and this is enough to say, no, there must be a process of inquiry. That had started with what Eleanor said to me around Fred's diagnosis being withheld for 17 years, I think. And that was the beginning of that process. But I didn't have because you saw in the minutes, people were saying, there is nothing, no more lessons to be learned. We've learned everything. That's what we were saying. We've disclosed everything.
And is it your view that the failure to have some form of independent inquiry, again, leave aside whether it's a public statutory inquiry or a Hillsborough-type panel, whatever it might be, but a failure to have something independent, was that a failure in your view of successive governments?
Absolutely. And I just want to come back to the point I was touching on a moment ago. I'm not accusing anybody of anything individual, of anything improper. I don't have the evidence to do that. I'm not in any way saying that the civil servants who put those things up to me, I think they were doing something wrong. Well, let's say there's a discussion to be had about, a debate to be had about that. What I think they were doing is there was the firmest of government lines that had been established for a long, long time, and they were having to live within that sort of straitjacket when they were putting advice to ministers, I think, and resist any opening up of, that was, I think, the clear instruction. And I think when I use the word criminal before, I must just make it clear that I wasn't necessarily relating that to anybody who I was working with in the department. That applies to what I began to collect from people like Eleanor and Fred. To me, withholding a diagnosis when somebody knows about a diagnosis, I would say, I would stand to be corrected by people with greater knowledge of the law than I have. But I have to say that sounds to me like a criminal offence, because obviously you can infect a family member, that's a very serious thing. I have an example of the falsification of a medical record by somebody else who I've got to know, who has given me the permission to use her name, Hazel Bullock, where her husband, Ken, who was a very senior civil servant himself, was, as a haemophiliac, was infected, and she battled to get his notes, and when she finally got his notes, after a long battle, it was full of suggestions of likes to drink at weekends, chronic alcoholic. To me, again, the falsification of a medical record is a criminal, I would say, a criminal offence. So I don't know whether there was any instruction ever given to people working, if you like, in the NHS about withholding diagnoses or kind of withholding medical records or amending medical records, or in this case, falsifying medical records. But I do believe that those acts are, as I say, are criminal acts. And I am also certain that there are multiple examples of that, hence the phrase criminal cover-up.
And just going back to how public inquiries or independent inquiries might come about, part of the problem will be if the inquiry potentially is into the decisions and actions of a department of the government, they may be the worst people to make a decision about whether there should be an inquiry or not. Do you have any suggestions based upon your experience over the years of how that potential problem could be addressed?
I mean, immediately it takes you to a sort of an independent arbitration function, doesn't it, within government that would go beyond the department itself. I think this is a very serious issue that you've raised, in that the department concerned controls all of the levers that would allow, would open an issue up: the access to information, the ability to steer things in a certain direction. And I think it does explain. I mentioned nuclear test veterans before, and the MOD would absolutely be a case in point with regard to that example. So yes, I think there's a case for is there some way in which there could be an independent body that a member of the public or campaign group could complain to with evidence to say that we believe this is unreasonable. I think it's all. I mean, this is maybe not the forum to say it, but I will quickly say it if you don't mind. I think it is to do though with our system of government and our parliamentary system. What I can say to you today, that from my experience in the House, and I was 16 years in the House of Commons, at least 1,000 MPs in that time were very engaged on this issue and writing countless letters, and actually did quite a diligent job, I think, for some of the constituents they had who were affected. But those letters were just bouncing off, and the question is why? Where's the real power here? I think personally that the whip system takes a lot of power away from elected representatives and hands a lot of power to the permanent structures of government. And the answer may lie actually in somewhere there. On this issue, there was a huge cross-party consensus that this issue had to be opened up. And I'll pay tribute to kind of people in all political parties actually who worked together. Obviously Diana Johnson in my own, but Alistair Burt. There was a whole heap of names I could kind of reel off of people who were really working hard to kind of prise the lid off this and get something done. But and these are very senior people, but they couldn't. And this inquiry is getting to the heart of something about the British state and something, because how many can I reel off to you today? This inquiry, but the poor people affected by Grenfell are 5 years on, and some would say, why are they still in the position that they are in? Hillsborough, I've mentioned. You could look at Bloody Sunday, nuclear test veterans. You can actually go through an extremely long list because this pattern keeps on repeating, and something is wrong here in that the system, I think, has too much control. And it's why I do believe there's a case for very significant political reform to give elected representatives more more power. But I think there's the call I've made through something called a Hillsborough Law, which we've put forward, is a statutory duty of candour on all public officials, and that would include civil servants and senior civil servants. Because in this case, I believe there must have been people in the Department of Health from the 70s onwards who would have had serious concerns about some of the lines that were being put up to ministers. And if there was a statutory duty of candour, that would have allowed them to break the cycle of partial briefing, incorrect briefing, without being in fear of their job for doing so, because there was a law that would require them to come forward with information that they knew would have changed the complexion of the issue.
And the Public Authority Accountability Bill that you advocated, and there's a debate in Parliament March 2017. I'm just going to read out the first paragraph of that because it will help those listening understand. We don't need to put it up, Lawrence, but it's RLIT 301577. You described it in these terms, that leave be given to bring in a bill to set a requirement on public institutions, public servants and officials, and on those carrying out functions on their behalf, to act in the public interest and with candour and frankness, to define the public law duty on them to assist courts, official inquiries and investigations, to enable victims to enforce such duties, to create offences for the breach of certain duties, to provide funding for victims and their relatives in certain proceedings before the courts and at official inquiries and investigations, and for connected purposes. So that was your summary in Parliament of the statute that you were hoping to bring in. Now that hasn't come onto the statute book. Does it remain your view that kind of law, which has been termed elsewhere, or by you or by others, as a Hillsborough Law, does it remain your view that is something that ought to be done?
It very much remains my view that is essential. Sir Robert Francis recommended a duty of candour with respect to medical professionals, and my understanding is that it has had some beneficial impact. This is a much more far-reaching duty of candour that would apply to public servants and senior officials, indeed possibly all officials. It is something that was recommended in the report by Bishop James Jones, who was asked to report on the experience of the Hillsborough families by the former Prime Minister Theresa May. He produced a report called The Patronising Disposition of Unaccountable Power. And his report, I think, was published in November 2017. And I think it is pretty disrespectful to the Hillsborough families that we're almost 5 years on and the government hasn't responded to that report. But the proposal of a duty of candour has widespread support amongst, I think, senior legal professionals, alongside, it has to be said, a provision for parity of legal funding at inquests where the state is involved. Because there's often a case where a disaster happens that people are brought into a courtroom, the public bodies, be they the police or the NHS, are spending public money with no limit on it to hire the best QCs in the land, and bereaved families are in a courtroom raw with grief with no access, scrabbling around for legal funding. You know, that also is something that is in the law and is critical, in my view, to the Hillsborough Law. There's also a bill, I think it's being heard in Parliament today actually, put forward by Maria Eagle, which I mentioned earlier, for a public advocate. And this might be something of the kind that you were touching on before, an independent body that bereaved families could go to. And this bill, the Public Advocate Bill, I think perhaps would have been relevant in the case of contaminated blood, because it would give people a powerful advocate to challenge the obstructiveness or the inertia of the state on behalf of bereaved families. I think all of this is important for many, just obviously for reasons of basic humanity and care and support for people affected, who often will understand that mistakes can be made. What they won't forgive is the cover-up that sometimes follows. But it also could save the country money. You know, here we are, decades on from when these issues were first known, and it's just not right that people, in my view, it's not right that people having to sit in this room on a hot Friday afternoon, people whose lives were ruined by these events, still fighting for justice. What has that taken from terms of the expense that that's caused everybody who's fighting, but also in terms of the state fighting these things? In the end, it costs money to operate in this way. It would be better for everybody if there was a duty of candour, that the truth was told at the first time of asking, and then reparation can be made at the first time of asking. I think that saves money in the long run, but it certainly saves a lot of distress and hardship for those who are most affected.
In opposition, in your capacity as Shadow Secretary of State for Health, and indeed more generally, I think, you've spoken in Parliament on a number of occasions about issues arising out of infected blood. I'm just going to read the dates and the reference numbers for 3 of those occasions, and then I want to look at the last one with you. So you spoke on the 15th of January 2015. The first 3 don't need to go up, Lawrence. RLIT 40771. You spoke in March 2015, RLIT 301575, and in July 2015, RLIT 301576. And those accounts stand for themselves. I don't propose to ask you about them. But you then spoke in April 2017 as you were about to stand down and running for election for your current position, Mayor in Manchester. And I just wanted to not read the whole of your speech, but just ask you about a couple of parts of it. So could we have this on screen, please, Lawrence? It's RLIT 0001578. 25th of April 2017. It's quite a long speech and debate, so I just want to go to a couple of passages and then ask you about it. So we just pick it up with the introductory paragraph. Through you, Madam Deputy Speaker, may I thank Mr. Speaker for giving me this opportunity to make what will be my last speech in this House. I make it on the subject of contaminated blood for a simple reason. Knowing what I know and what I believe to be true, I would not be able to live with myself if I left here without putting it on the official record. I will be honest, this is a speech made with a sense of guilt, in that all of us here are collectively culpable of failing to act on evidence that is there before us if only we care to look, and by extent, failing thousands of our fellow citizens who are the victims of perhaps the greatest untold injustice in the history of this country. And then if we could go to the last paragraph on this page. And this picks up on something you've already said to us, Mr. Burnham, which is why I wanted to read it again. Here is what I think is the crux of the problem. Contaminated blood has always been viewed through a financial prism. That suits the government. It keeps the victims in a position of subservience, forced to beg for scraps of help from the various funds that have been set up. By the way, let me make it clear that I am talking about not just this particular government, although I am talking about this government, but all governments. To the extent that the public know anything much about this scandal, there is a vague sense that it is an argument about money. In my view, it is in the government's interests to keep it there. They want to keep it there. Why is that? Just as with Hillsborough, if the great British public knew the real story here, there would be such a wave of public support for the victims that demands for full and fair compensation simply would not be able to be resisted by the government. That is the experience of Hillsborough. When the truth was told, such was the huge groundswell of popular support that there had to be action. Perhaps that is why the government do not want the truth to be told. They know that there will be little place for them to go in answering those calls. And then you go on to explain that you had brought this debate to the House to try and break through that impasse. Does everything you said there remain your view today, Mr. Burnham?
Yes, it does. Every single word remains true, and I would stand by it. We've demonstrated today the the lines that they had. I remember one of the briefings put to me around this time was about preparing strong defensive lines for the government's position. They simply didn't exist. There weren't any strong defensive lines for the government's position. They were threadbare lines. They were falling apart around us through the March judicial review, or for other kind of challenges that they were under. So no, it absolutely is my view that is, and obviously there is the element of victim blaming. In this case, it was an argument all about money. Or in the case of Hillsborough, oh, those Liverpool supporters, weren't they? Well, no, because they were vindicated on every single count at the second Hillsborough inquest that came. And it's that thing, isn't it? That's how the system sometimes works. It tries to sort of take pressure off itself by, oh, there's surely something wrong over there with some of these people. Like poor Ken Bullock, you know, called an alcoholic when he never is, according to Hazel, he would have an occasional glass of wine on a birthday, you know. I mean, how does a man like that, a senior civil servant, get to have a kind of defamatory medical record left? What is going on there? But, you know, there's other examples. I've heard of so many examples of people having tests without their consent. Even their children have had tests without consent. I think I referred to in this debate gave examples of that. And so I stand by, you didn't read it out, but I will read it out again, a criminal cover-up on an industrial scale. So yes, I stand by that too. And that word criminal relates to medical records falsified, deleted. It relates to tests being done without consent. But it relates to also to diagnoses being taken without consent. I think what I need to do today, if I may at this point of my evidence, is kind of take this a step further, if you like. Why was there a criminal cover-up on an industrial scale? If you look back over the 5 decades, and I mentioned before that over 5 decades the government had not done enough at all, you know, failed the people who'd been victims. But through the 70s, what did we see? Well, we saw a recognition of the issue of the risk of imported blood products and a drive to increase capacity, but that didn't come through, did it? And it kind of got lost in the 80s, and there still wasn't the capacity at that time. Then, if you kind of take it forward into the 80s, I pointed the chair today to a memo from the Oxford Haemophilia Centre that I would say is another case of extreme negligence, if you like, of the welfare of people with regard to products being given in the way that was described there. But I would also say, if you bring it forward to the kind of first 2 decades of this century, so we're going right through here, aren't we, 70s, 80s, into the 90s, you know, kind of maintaining these lines, and then the first 2 decades of this century, not provide for people in a very desperate circumstances, not providing financial support for them. That too damages not just physical health, but mental health too, if you leave people in the wilderness in that way. So I guess if you summarize everything that I'm saying here and have now come to believe, I think that the Department of Health and the bodies for which it is responsible have been grossly negligent of the safety of the haemophilia community in this country. And I would add to that, from there, I would say there is even the possibility that the CPS should be asked to consider charges of corporate manslaughter. And I don't say that lightly. I'm not coming here to create. I thought, from the moment I called for this inquiry, when in my final speech, I've thought about if I was called, what I might say here. And obviously, I've been rereading over things recently, and I've got a lot of regard for people in the Department of Health, but I think on this issue, they've got it fundamentally wrong from the 70s onwards. And the reason why I believe I can justify the statements I've just made, I think I can provide evidence about the cover-up, and I think I have done today. But, you know, they were negligent in not following through on self-sufficiency, even though it was clearly stated that that is what would do most to protect the citizens of this country. If we were self-sufficient in blood products that we knew came from donors who weren't paid, we would be our citizens would be in a safer position than relying on products where people were paid. And the failure to follow through on that is negligent of people's safety, but particularly of people in the haemophilia community. Secondly, having not done that, then conducting trials of these products that was continuing to change without proper consent, proper mitigations or safeguards, as it would appear to me they did, that was grossly negligent of the health and safety of people who were subject to those products. And then thirdly, not to provide financial support which is commensurate with the physical and mental distress of the people who've suffered through no fault of their own. That too, in my view, is grossly negligent. And then when you add it all together, I personally can come to no other conclusion. I heard what Sir Robert said about the moral case, and I understand perhaps that he can't go further because he hasn't been asked to look at that. And I appreciate that the inquiry may take a different view. But I think there is a clear case to me that there is a massive legal liability here for being grossly negligent of people's needs. And I think in the law related to corporate manslaughter, it's about scant regard for people. I think if you look back at those submissions that you've been putting to me today, where is the regard for the concerns of the people affected? Where is the statement about that? It's not there. So policies were being done without any consideration. If we do this, it's going to have that impact. There was no regard. So as I say, I'm not coming here today to just throw a few, I have thought very carefully about this, and I can come to no other conclusion that it maybe put whether or not there is a case for corporate manslaughter, because the law is complex in that territory. I certainly think it should be looked at. But given what I've said, it's not just a moral case for significant, immediate compensation. There is a rock-solid legal case for it, in my view, and that's why I very much welcome what the chair of the inquiry had to say at the start of today's proceedings.
And in that speech you gave in April 2017, as your last speech in Parliament, is it right to understand that two of the practical, concrete things you called for were some form of independent investigation and inquiry? And then secondly, if we go to the bottom of page 7 of the Hansard report, please, Lawrence. I can just pick it up in the last 2 lines. You respond to something said by one of your parliamentary colleagues, and you say absolutely there must be full, fair compensation now. I say to the government, do not delay. Do what Ireland and other countries have done. They should do that now. They raised expectations and they should do it. We would all support it. So April 2017, you called for, as you describe it there, full and fair compensation.
Absolutely. And I was pleased to hear what the chair had to say. I would like to praise the government for establishing the study into a fair compensation framework. I think that is a big step forward. I would like to praise the Prime Minister, Theresa May, who initiated this inquiry, obviously with some of my input as well. But she and I worked together on Hillsborough, and we worked together on this as well. But it's 5 years ago now. It's 5, as everyone said today. What have those 5 years meant to these thousands of people who've been left struggling? It was 5 years they'll never get back. And this dragging of feet in the British government civil service, in whose interest, what justifies that? just because you're trying to please the Treasury or what, it's not. There isn't a justification for it, in my view. And I credit, I think, to Penny Mordaunt, who initiated the study into the financial compensation. But I would say we're in a position where we're in limbo, aren't we, as a country at the moment, with the changes that are going on. I just hope that people can hear what's coming out of this inquiry and act now. Support people now. Don't make them wait a day longer.
So that covers the issues that I was proposing to explore in terms of my own questions, and also a lot of what I've asked has reflected suggestions made to me by core participants. But obviously we must give an opportunity for further questions to be suggested to me, arising not least out of the evidence that Mr Burnham's given already today. So could we take our afternoon break now, perhaps until 3:30, so perhaps 5 minutes longer or so than normal, and hopefully that will provide enough time for any further questions to be considered by me.
Yes, let me just say a word of explanation. The law provides that core participants who are legally represented may, through their legal representatives, put questions to counsel to ask of any witness. And they must obviously be given a chance to do that, particularly having heard what you have said today. I don't know how long it'll be. Council will have an idea. She's suggested not before 3:30. I shall say not before 3:30 because if questions come in, as they do sometimes rather late, then she has to have time to consider how best to put those to you. And it may be therefore a little bit later. But it's an essential part of fairness that everyone has a chance to participate in this inquiry. It's part of our commitment to openness and transparency, and in this case it's underpinned by the law. So that's what we'll do. We'll take a break now until no earlier than 3:30. I can't tell you, I'm afraid, how long after 3:30 you'll be detained. It'll all depend how many questions there are.
Chair, could I, if you don't mind, just ask a question of you?
Yes, certainly.
Respectfully, will there be any further chance to comment if there are no further questions on my part?
We always allow any witness, we invite any witness to say what they want to say at the end of the questioning, and you will have that chance just as any other witness has had.
Thank you.